A question that I've been receiving from a lot of my clients who have these green card applications pending is, what if I just withdraw my application and leave the US to consular process? Hey guys, so we are receiving some disturbing reports of people being detained at their USCIS marriage-based adjustment of status interviews after having no immigration or criminal violations apart from overstaying the visa that they used to enter the US. Historically, this has never really happened before. Someone who is a simple overstay can usually adjust status pretty easily through marriage to a US citizen. I've been handling these cases for over a decade. I have never once had a client detained at one of these USCIS interviews. I'm not saying it was impossible to have happened, but it's never happened to any of my clients, and it wasn't something that was really on my radar as a realistic probability unless you had criminal history, an old deportation order. More recently, even if you have criminal charges pending, that was a major risk of showing up to the interview, or some history of major immigration violations or fraud or something questionable like that. We also saw reports of some people from certain countries like Iran just being arbitrarily detained even though they had adjustment of status applications pending and appeared to never have been out of status. So a lot of random stuff happening, but recently, over the last week or two, we've heard reports out of San Diego and Los Angeles USCIS offices of people with no history of immigration violations aside from overstaying their visa being detained at the immigration interview. And it seems like the USCIS officers at those offices are directly communicating with ICE officers in the building, because from what I heard, during one of the interviews, the USCIS officer went through the whole I-130 portion of the interview where they asked the spouses questions about their marriage. They determined that it was a good faith marriage. Then they move on to the I-485 portion of the interview. And then as soon as they asked the client whether he overstayed or violated the terms or conditions of his visa, and he said, yes, I overstayed, ICE officers entered the room and detained him. Now, those people who are detained are gonna need to hire another lawyer to apply for a bond and to be released. When you're detained under those circumstances, you could be detained for a couple hours and then just receive a notice to appear and get released. But that's becoming less and less likely. It's more likely that you're gonna remain detained until your lawyer files a court case to have you released on a bond, which could take at least a few days or weeks in some situations. So let me start by saying this is absolutely terrifying for everyone involved, including me. This is not good news, and this really makes the immigration process much more complicated. A question that I've been receiving from a lot of my clients who have these green card applications pending is, what if I just withdraw my application and leave the US to consular process? Well, it's not that simple. It might be an option for some people, but there's a lot of things to consider. So first of all, if you've been unlawfully present, if you overstayed your visa for more than 1 year, if you leave the consular process, you're gonna trigger a 10-year bar preventing you from re-entering the US. You can't leave the US if you have more than 1 year of unlawful presence without triggering the 10-year unlawful presence bar. The way to avoid triggering it would be to apply for an unlawful presence waiver from within the US, but that process can easily take 3 or more years. And frankly, if your green card application is pending, you're probably gonna get interviewed within a few months, so you just don't have that much time. It's not really an option to do that. But what if you haven't overstayed by more than 180 days, which would trigger a 3-year bar, or a full year, which would trigger a 10-year bar? You have an adjustment of status application pending, you haven't overstayed at all. You filed the application before the duration of stay on your ESTA or tourist visa expired, and you're just waiting for your green card interview. Well, in those situations, I think the chances of getting detained are lower, much lower. In fact, I think a common theme amongst the people who were detained in San Diego and Los Angeles was that they overstayed. So whenever possible, I would probably try to file the application before you're unlawfully present in the US. And for other people who have been unlawfully present, but by less than 180 days so that if they leave now, they're not gonna trigger a 3 or 10-year bar, there are a couple other things to consider. So first of all, if you used ESTA or a tourist visa to enter the US, the moment you filed your adjustment of status application, you're no longer in a valid tourist status. In fact, you no longer maintain the non-immigrant intent to be able to travel to the US as a tourist. So effectively, your tourist visa was canceled the moment you filed that I-485 application. If you leave the US now to pursue the process abroad, you'll have abandoned the I-485 application, you'll lose all your fees. That's not the end of the world. If you withdraw it right now, you might get a notice to appear in immigration court if you're still unlawfully present in the US when you withdraw it. But a bigger problem is that, yes, we can transfer your case to a consulate abroad. That could easily take like 2 years, sometimes even 3 years, because first we have to transfer it, and lately that's been taking a while. But you're not gonna be able to travel to the US as a tourist while the case is pending. So if you have less than 180 days of unlawful presence and you're worried about getting detained, we could transfer your case to a consulate abroad. It might take 3 years before you can legally re-enter the US though, so that's the major consideration to keep in mind. Also, it seems like this is like a private policy or a pilot program that they're beginning to implement in just parts of California right now. I do expect this, and other immigration lawyers have also said that they expect this to expand to other parts of the US based on how successful it might be in California. We'll see what happens with that. My assumption is that this will eventually spread. This week alone, I had several marriage-based adjustment of status interviews in the New York region, different USCIS offices. No one had a problem. In fact, most of them have already been approved, like 48 hours later. We already know that the cases got approved, and I expect 100% of them to actually get approved, of the cases that we had this week anyway. That doesn't mean that's true for all our future cases. So, past results do not guarantee future performance, or whatever the phrase is. Disclaimer there. Anyway, guys, these are scary times. This is rattling me, and I have tons of clients. In fact, my practice focuses on marriage-based adjustment of status. So if this becomes a widespread practice, you should expect at the very least several more videos from me giving you updates and tips and tricks on how to stay safe. So if you're trying to go through the immigration process and you need a lawyer, you could always schedule a consultation directly with me. The link to schedule is in the video description below. If you're new to my channel and you just want to stay up to date on what's happening in immigration world and get the latest info and tips and tricks, be sure to subscribe to my channel, and I'll see you guys next time for another video.